Welcome to the Supreme Court press call. My name is Darrell, and I'll be your operator for today's call. At this time, all participants are in a listen-only mode. Later, we will conduct a question-and-answer session. During the question-and-answer session, if you have a question, please press star, then 1 on your touch-tone phone. Please note that this conference is being recorded. I will now turn the call over to Elizabeth Wydra. Elizabeth, you may begin.
Thank you so much, Darrell. Good morning, everyone, and thank you for joining us on this rainy morning for the discussion of the Trump versus Mazars and Trump versus Deutsche Bank cases. As Darrell mentioned, my name is Elizabeth Wydra, and I'm president of the Constitutional Accountability Center. CAC and I are delighted to host this discussion of the array of outstanding amicus briefs that were filed last week in support of Congress's power to access the information it needs to fulfill its core investigative function. CAC has long been involved in issues of congressional oversight, as well as those related to accountability to the rule of law. Accountability is in our name. It's something that we care deeply about. And that commitment led us to file amicus briefs in these cases, focusing on the long history of congressional investigations. The Supreme Court's repeated affirmation of Congress's broad power to investigate is coextensive with the scope of Congress's power to legislate. As you'll hear later in our brief, we argue that the House Committee's request plainly serves a legitimate legislative interest and would aid its consideration of whether and how to legislate on key financial disclosure requirements and presidential conflicts of interest, which have become obviously increasingly urgent given the current climate. On the call, you'll hear short presentations from leading voices on 4 briefs that were filed in the Supreme Court. Yale Law Professor Harold Koh will discuss the brief filed on behalf of former national security officials. Next, former House General Counsel Irv Nathan will discuss the bipartisan brief filed on behalf of former House General Counsels and former congressional staff. Next, AEI resident scholar Norm Ornstein will discuss the brief filed on behalf of congressional scholars. Finally, our own fabulous CAC Chief Counsel, Brianne Gorod, will discuss our brief. And after that, we'll open the floor to your questions, which we look forward to. To conclude with my initial remarks, I just would like to point out that this incredibly important pair of cases comes at a fraught time for the Supreme Court. The precedents in this area of the law are overwhelmingly on the side of Congress, yet President Trump, as he has done in past cases, is counting on the 5 conservatives to simply vote lockstep in his favor and ignore those precedents. At the same time, Chief Justice John Roberts has repeatedly said that he wants to keep his court above politics, and he faces immense pressure there, and that is a deeply difficult task in light of these cases. But even though the law is clear, we won't really know more until the end of this month and after and during oral argument to see whether or not Chief Justice Roberts is prepared to follow those clear precedents to sustain a bedrock of our Constitution's separation of powers. Thank you all again for taking the time to join us for what we hope will be a very useful discussion. And with that, let me turn the call over to Professor Koh.
Thank you, Elizabeth. So I'm representing the Peter Gruber Rule of Law Clinic at Yale Law School. We filed on behalf of 20 former national security, foreign policy, and intelligence officials, and they include former CIA directors or acting directors Mike Hayden, John Brennan, and Mike Morrell, the former DNI, Jim Clapper, 2 former Deputy Secretaries of State, Strobe Talbot and Jim Steinberg, and former Director of National Counterterrorism Center, Matt Olson, among others. We make basically 3 points. The petitioners and the Solicitor General suggest that somehow, and they do it in a very sort of attenuated way, exemption from congressional subpoenas is somehow necessary to preserve various national security concerns of the presidency. We argue that the national security considerations actually cut the other way. Money laundering and foreign influence backed by illegal finance are among the most serious threats to our U.S. national security. We have about $1 trillion, $1 to $2 trillion of money laundering a year globally, $300 billion in the United States, and funds from those sources are used for transnational crime, terrorism, foreign intelligence activities, and also efforts to influence elections and also officials. Second, because the framers of the Constitution foresaw these threats, accordingly they gave Congress a key historical role in oversight and investigation to protect us from those threats. And Congress has used that authority vigorously over the years in passing a whole series of laws, not just with regard to regulation of foreign agents, espionage, but also conflicts of interest. And all of our clients were subjected to these conflict of interest laws and obeyed them and oversaw them when applied to other executive officials. Third, what the petitioners and the Solicitor General are proposing here, which is the creation of a new exemption from this congressional authority, would leave the nation vulnerable to national security harm. Our simple point is that the court should not be in the business of generating national security blind spots. These are not areas where the public can monitor without information, or where the executive branch can self-regulate, or where we can reasonably expect Congress to exercise oversight unless it has a reliable subpoena power. And so for all these reasons, we say that the court would actually cause national security harm if it created a new exception that immunized the presidency from lawful oversight in the areas of money laundering, illicit finance, and foreign influence. So that's the position that we take. And with that, let me turn it over to Irv Mason for the House General Counsel's brief.
Thank you, Professor Coe. Our brief was filed on behalf of a bipartisan group of several former House General Counsel, of which I'm one, and also a bipartisan group of former top congressional staffers. Our main point is that these cases should have been handled like the Eastland decision written by Chief Justice Berger decades ago. We focused on the need for expedition because based on our experience, we know that the House only exists for a 2-year period and is not a continuing body. Subpoenas need to be promptly enforced and complied with if Congress is going to receive the information in time to take appropriate action within its short time frame. Because of the speech or debate clause of the Constitution, the motives of Congress cannot be challenged in court, and because of the presumption of regularity, subpoenas need to be deemed valid and enforceable. The district courts in these cases acted appropriately. They held prompt hearings and shortly thereafter issued rulings upholding the subpoenas. But the Trump lawyers, aided and abetted by Mr. Barr's DOJ, exploited the court mechanisms in an effort to run out the clock, even though they know their positions have no merit. And the courts, in our view, have either been manipulated or willing accomplices in these delaying tactics. There never should have been any stays granted because the district courts had it right, and because the equities favored the House and required quick resolution. Because of these stays, the House has been unduly and unfairly delayed in carrying out its constitutional responsibilities. In our view, there's no need for more delay, and in our brief, we urge the Supreme Court to lift the stay before it even issues its written opinion later in the term. Our brief made it clear that, in our view, the goal of the Trump team, with its frivolous arguments, is to run out the clock so that no damaging information is released before the election. We suspect their plan is to get a decision in late June, urge their accountants and banks to slow-walk the response, and not turn over the documents until it is too late for the Congress, with its planned summer recess, to do much with them. We hope that the Supreme Court will not let this strategy succeed. I'll now pass the baton to my good friend Norm Ornstein, who was an amicus for me in the Myers subpoena enforcement case during the Bush administration, which sets the precedent in this area. Norm?
Thanks so much, Irv. And, of course, back then we had a strong bipartisan agreement about the powers of Congress. Exactly. So the brief that I'm dealing with was one of congressional historians. There were 4 of us. Besides myself, Tom Mann, a longtime senior fellow in governance studies at the Brookings Institution, who, along with me, has written extensively about Congress, including congressional history. Mort Rosenberg, who's now a scholar at the Project on Government Oversight, but spent 35 years as a senior legal analyst at the Congressional Research Service, where he was the go-to person on congressional procedures and practices. And Brenda Wineapple, a historian who's written about the impeachment of Andrew Johnson, among other things. Our brief is really about the assertions made in the dissent that Congress cannot investigate a president or, by extension, other officials who could be impeached without starting a formal impeachment proceeding or unless there is a direct legislative need. The dissent used a number of historical cases to try to make that point. What our brief does is to go systematically through each of those cases and some others from the founding era and beyond, which make it very clear that the dissent misused information or did not adequately express the reality, which is that from the founding era, Congress investigated presidents and other impeachable officials without starting an impeachment proceeding and have continued to investigate throughout the course of history without having to do a formal impeachment investigation. That the bottom line for us really is that it is a fundamental element of Congress that it be able to investigate wrongdoing by officials and determine whether, in fact, it makes sense to start an impeachment investigation or to take other remedial actions to deal with corruption or maladministration. And with that, let me turn it over to Brianne Gorod.
Well, thanks, Norm. I'm Brianne Gorod, Chief Counsel here at CAC, and as Elizabeth mentioned earlier in the call, we filed an amicus brief in these cases, just as we did in the Second Circuit and in the D.C. Circuit, discussing the long history of congressional oversight and the Supreme Court precedents that have consistently recognized the breadth of Congress's oversight power, as well as explaining why the subpoenas at issue in these cases are plainly valid. So I'll just make a few quick points. First, as Norm just discussed, Congress has been engaging in oversight, it's been engaging in investigations since the earliest days of the Republic. As early as 1792, Congress asked for records from the Washington administration as part of its investigation of a military defeat. And numerous members of Congress, including James Madison, including other framers, voted in favor of the inquiry. That investigation was only the first of many other congressional investigations that have followed in the years since. And that long history matters. It matters not only because it helps shed light on the original meaning of the Constitution and the powers that it gives to Congress, but also because the Supreme Court has long recognized that in cases involving the relationship between the branches, historical practice is often given significant weight. And so here, that historical practice clearly supports Mazars and Deutsche Bank being allowed to comply with the subpoenas issued by the House committees. Second, consistent with this long history of congressional investigations, the Supreme Court has repeatedly affirmed Congress's broad power to investigate. And it's reiterated that the scope of that power is coextensive with the scope of Congress's power to legislate. It's also made clear that oversight authority is critical to Congress's ability to do its job. It's critical to its ability to fulfill its institutional responsibility in our system of checks and balances. As the Supreme Court itself has put it, a legislative body cannot legislate wisely or effectively in the absence of information respecting the conditions which the legislation is intended to affect or change. And where the legislative body does not itself possess the requisite information, recourse must be had to others who do possess it. And in another case, the Supreme Court said there can be no doubt as to the power of Congress, by itself or through its committees, to investigate matters and conditions relating to contemplated legislation. This power, deeply rooted in American and English institutions, is indeed coextensive with the power to legislate. And the court continued that without the power to investigate, Congress could be seriously handicapped in its efforts to exercise its constitutional function wisely and effectively. All of which is to say, the President's efforts to keep Mazars and Deutsche Bank from complying with these subpoenas are at odds with decades and decades of Supreme Court precedent. And third and finally, our brief argues that the committee subpoenas plainly serve legitimate legislative interests, as they'll help Congress determine whether it should strengthen financial disclosure laws and impose new restriction on presidential conflicts of interest, as well as whether and how to strengthen federal banking laws, particularly with respect to lending practices and the prevention of money laundering and loan fraud. We've obviously already heard from Professor Coe about how important this is from a national security perspective, and other amicus briefs, including one filed by former federal ethics officials, also address the importance of federal ethics legislation and Congress's ability to engage in oversight on that topic. So these briefs and many others that were filed in these cases all underscore how important it is that Congress be able to engage in oversight if it's to be able to do its job. And that's why these cases are so fundamentally important. They're not just about this president and this Congress, but about whether future Congresses will be able to function effectively. So with that, let me turn it over to the moderator to open up the call for questions and answers.
Thank you. We'll now begin the question and answer session. If you have a question, you can press star then 1 on your touch-tone phone. Once again, if you have a question, press star then 1 on your touch-tone phone. And I'm standing by for questions. And once again, it's star then 1. And we have no questions at this time. Oh, wait, we do have a question. Okay, Adam Liptak from the New York Times, go ahead.
Hi, everybody. Thanks for doing the call. I don't think I've heard anything about the Vance case. Do you guys take a position on that case?
Yes, this is Brianne at CAC. So, separately we filed a brief in that case taking the position that the subpoena issued by the New York DA should have to be complied with. We, in that brief, filed a brief on behalf of a group of former Department of Justice officials, a bipartisan group of former Department of Justice officials, taking issue with the assertion made by the president's lawyers that Department of Justice briefs and memoranda have taken the position that presidential immunity would bar compliance with the subpoena in that case. That is just fundamentally wrong, as we explain in our brief. And that brief, details the history of DOJ briefs and memoranda that, in fact, set out a balancing test that should be applied when considering the president's amenability to judicial process. And, we also explain, again, on behalf of a bipartisan group of former DOJ officials, that applying that balancing test that the department has consistently applied in the past would suggest that the subpoena should have to be complied with in this case.
And do you think the cases rise and fall together, or is the analysis different?
I mean, I think, there are very different legal issues presented in both cases, and so while we obviously think, the court should recognize that the subpoena should be complied with in both cases, and they're obviously both very important because, they will affect the ability of both Congress and grand juries to carry out the very important roles that they're responsible for, the legal issues are distinct. So I think it's certainly possible that we could see different outcomes in the two cases.
Adam, it's Harold. Adam, it's Harold Coe here. I'm actually a client on the brief in the Vance case because I worked at the Office of Legal Counsel in the 80s. The analysis in the Vance case is much more about the scope of Nixon versus the Nixon tapes case. And it's an analysis of Randy Moss's opinion for the Office of Legal Counsel in the famous assertion that the president's immune was actually based on a notion that the president would still be subject to a grand jury investigation and therefore a fortiori subject to the grand jury investigation brought by Cy Vance Jr. This case is much more about the one that we're talking about, Mazars and Deutsche Bank, about whether Congress has legitimate authority both to legislate and to subpoena with regard to matters about money laundering, illicit finance, and foreign influence, which are all being alleged, and that whether there's some kind of immunity that the courts should or have created, which clearly they have not. But that's what they're arguing for.
Thank you.
And if anyone else has a question, you can press star then 1 on your touch-tone phone. And our next question comes from Greg Storr. Go ahead, Greg.
Hi, I think this question is mostly for Irv Nathan, but others may have thoughts on it too. I'm just wondering if there was ever a reason why the committees could not have invoked the impeachment power in issuing these subpoenas. I recognize that you're talking about the principle that they shouldn't have to do that, but as a practical matter, was there any reason they couldn't have done that and averted this Supreme Court fight?
Well, I don't know that they would have averted the Supreme Court fight, and of course I'm not at the House now, but my understanding is, first of all, the subpoena was issued before the impeachment inquiry began, and it was a part of a congressional oversight and legislative efforts that was described by Chairman Cummings in his explanation for the subpoena, the dissent by Judge Rao is completely unprecedented. There's no basis for this. There was no reason for them to identify the impeachment inquiry. And by the way, by the time she wrote it, which she delayed about 3 months before she wrote it, then they were in the impeachment proceeding. And, to have a talismanic label to put on it made no sense. And, of course, I would note that even the Trump lawyers are not relying on that dissent to make their case in the Supreme Court. So I thought there was no basis for the dissent, and that the majority opinion, both by Judge Tatel and then the one by Judge Newman in the Deutsche Bank case, again, Judge Newman, of course, had been a top staffer in the Senate for Abe Rubakoff and understands the issues there. These dissents, and particularly Judge Rao's, make no sense, and I don't think they needed to be addressed.
And once again, if anyone else has a question, you can press star then one on your touchtone phone.
Oh, it's Harold Coe. If I could just add something to what Irv said, which I completely agree with. One interesting thing to notice is that in the briefs that have been filed, there's a difference in the posture of the petitioners and the Solicitor General. The petitioners are basically arguing that the committees need to make a greater showing of need than relevance to get these documents, where the Solicitor General is jacking it up to argue that there's immunities from the subpoena because they involve activities of the president. But, even if they were correct, which they're not, there's absolutely no reason why this would immunize or prevent Congress from acting with regard to legislation that might target the people who are acting upon the presidency, those doing money laundering or foreign influence, or why Congress couldn't take action to shield the rest of the government or to make the president's actions more visible to the press and people like you. And so the idea that somehow there's some sort of blanket blind spot is really the core of the position, and they don't even agree on what the legal basis for that might be.
We have no more questions at this time.
Okay, well, this is Elizabeth Wydra again. On behalf of everyone here at CAC, thank you to our panelists for your wonderful explanations of the briefs that you filed in these important cases, and thank you to all of you who joined us on the phone. If you need to follow up about anything on this call, you can contact Doug Pennington over here at CAC, and he can direct you to the best person to answer your question if he can't answer it himself. So thank you again, and have a wonderful day, everyone.
Thank you very much.
Thank you.
And thank you, ladies and gentlemen. This concludes today's conference. Thank you for participating. You may now disconnect.